Hello, I'm Diane Birnholz. Brian Walsh's criminal trial was scheduled to start last week on October 20, 2025. He's been charged with murdering and dismembering his wife, Ana Walshe, back in January of 2023. Ana's body has never been found. Now, a month before trial, Brian Walshe was stabbed in jail by another inmate. This was on the night of September 11, 2025, in the Norfolk County Jail in Dedham, Massachusetts. Authorities apparently haven't yet identified the attacker, who used some kind of a handmade shank or weapon. Now, Walshe was immediately given first aid by jail officials and then taken to a hospital in Boston. He was released back to jail the same night, just a few hours after the stabbing. And keep in mind that high-profile defendants are often more at risk of attacks in jail, just like this one. Based on the stabbing and its claimed effects on Walshe, his defense attorneys asked the judge to delay the trial in order to conduct a competency hearing. Defense attorneys expressed their concerns that Walshe is having serious mental health issues and experiencing nightmares and extreme stress because of the stabbing. Prosecutors opposed a delay, saying medical records don't back up these claims and that huge adjustments would need to be made in scheduling a large number of witnesses for trial. The prosecution also pointed to the fact that Walshe was only in the hospital for a few hours, suggesting that his injuries weren't all that serious. Well, the judge disagreed with the prosecution and said mental health and a defendant's ability to participate in trial are paramount and are more important than scheduling witnesses. So the court ordered an evaluation as to whether Walshe is competent to stand trial. So what does this mean? So first, keep in mind that a competency hearing is completely different from an insanity defense. Competency isn't a legal defense to a crime the way an insanity defense is. Competency is required to have the trial in the first place. The U.S. Supreme Court has ruled on this, and the inquiry really boils down to whether a defendant understands the charges against him and is able to work with his lawyers and make decisions. The notion is that it violates constitutional requirements of due process to proceed in a criminal case against a defendant who is not competent. Now, being under stress is not the standard, and I would imagine just about all defendants who are charged with murdering and dismembering their wives are under stress. The trial court orders this hearing, and a failure to do so could be reversible error. The competency hearing was scheduled for October 27, but that's just been postponed as the psychiatric doctors at Bridgewater State Hospital say they need more time to make this evaluation. I'll keep you posted. Thank you.